following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the laws related to the protection of Sri Lanka's unique environment. Recently, a discussion has arisen pertaining to the country's air pollution levels. This is on the backdrop of increasing calls of deforestation and disregard of environmental elements that have had a long history with the Sri Lankan civilization. Do we have the required laws in order to protect these precious resources? How is the international community responding to this matter? Should law enforcement be strengthened to face environmental issues of the 21st century? Welcome to Law, Land and Liberty, where we're keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Now, these days, the conversation on the environment has arisen once again, and primarily because of air pollution issue. And this has been affecting almost everyone. We saw even last year that many millions of people have died all across the world due to air pollution. And these are not things that should be taken lightly, specifically when it comes to issues of the environment, and specifically because we are a country that have benefited from having an amazing environment, for that matter, who has supported the Sri Lankan civilization for quite some time. So we need to get a breakdown of what are the legal elements that are present in order to be enforced so that the environment, the various sources, the flora and the fauna can be protected on a large scale. To understand that, we have with us none other than Professor Kokila Konasinghe, an individual who is an expert in this field. She's a professor in environmental law at the Department of Public and International Law in the University of Colombo, and she's the founding director for the Center for the Environmental Law and Policy. Thank you so much, Doctor, for joining us today. A lot of things to discuss with Professor Kokila with regards to this topic, but before that, as usual, we will give a breakdown of how we carry on this topic. We'll give a breakdown for our viewers so that it's easy to track how we'll take this discussion forward. Firstly, we are going to talk a bit about the fundamental law that governs the environment within our country so that we have a basic idea, a basic picture of what it looks like on the ground. Secondly, we'll look at the remedies that are available, and we'll talk about primarily two mechanisms which the professor will be giving us a breakdown of, which a lot of people would not have a proper idea as of now. And finally, we'll talk a bit about the international influences to environmental law and the reforms that are required.
Hi, my name is Rahul and I'm an engineering student. Today, my question is on the National Environmental Act. What are the principal enactments pertaining to the environmental law in Sri Lanka?
All right, let's get into the discussion. Director, Professor, thank you so much for joining me once again. I think it has been some time before we met, and it was pertaining to certain actions that were with regards to child protection, if I'm not mistaken, last time we met. But this is a field that you have been dedicating a lot of your time to, and I think even amongst peers within our the media circles also, Doctor's name has come up multiple times when it comes to this issue of the environment. And it is very important that we get this breakdown, because general matters left aside, when it comes to the environment and the protection of either forests or the general primary sources such as even animals, there is a bit of a lax in terms of how people see it. They are not too they don't fear the law that much in most instances, and that is a long-term sort of problem. A lot of things that I want to get a breakdown from you, Doctor, but firstly, if we can start off with the basic law, the fundamentals. Now, people are aware of the National Environment Act, and then there was a conversation about an animal protection bill and the rights of animals that should be governed, a proper criminal sort of element to be brought in there. Where are we right now so that we can, begin the discussion from that point?
Yes, Ayubowan Danidu. Now, I think talking about environmental law legal framework in Sri Lanka, we are in a very good position. Someone would think that what I am talking about when I say we are in a very good position. What I meant was that we are in a very good, we have a very comprehensive legal framework. So law is there. The problem is, as it always been, is with the enforcement. So if I say that if we look at the environment, the main key legal component is in National Environmental Act, which covers actually many areas, many sectors of the environment, nature. And also we have many acts, ordinances, even that were established long time ago, covering many other areas of environmental protection. For example, if we take Fauna and Flora Protection Ordinance, which was established during the colonial time in 1930s, and ever since it has a couple of amendments, but it is in a very prominent way protecting Sri Lankan fauna and flora. And also Forest Ordinance, which was late early 90s. It was established, but since then, even today, we have this Forest Ordinance with many amendments. So likewise, we have, if you look at the entire spectrum of environmental law, we can see that there are many areas that we can focus on, and most of the areas have sufficient legal framework. For example, if we look at in the criminal liability, so we have Criminal Procedure Code as well as Penal Code to protect and prevent any kind of damages caused to the environment in terms of criminal liability. And also if you look at civil liability and other areas like delictual liability, we have sufficient laws. So to answer your question in brief, that we have National Environmental Act as the main legislature, but other than that there are many other areas that have been covered by the law. So I think we can discuss further in which areas that we are finding remedies, but we have sufficient laws. I think nearly around 114 acts related to environmental law that is currently existing within the Sri Lankan legal framework.
Right. Professor, sorry, I need to give you some time properly to elaborate on the remedies so that we can give our viewers a breakdown of, I think you will be explaining two very distinct approaches there. Before that, if we can just get a bit more clarification, Professor, we see the law generally arises when there is a need or a motive that the government or the entire country has. Now, my very bluntly, if I put, is climate change an objective that we are focusing on right now? Because we have to balance both sides. You know, there is a requirement for development, that all of that needs to happen as well. But the issue of climate change, now it's being discussed extensively, almost obsessively by certain countries, maybe without no proper action plan. But when it comes to Sri Lanka, is that an objective of ours? Are we looking at that in a more holistic approach, or is there legislation that looks into it? Or are we, because when you say we have the laws that are required, then I think we are almost there, I think, in terms of what we need in terms of the framework, which wasn't the case that generally a lot of people would have believed in. But yes, just to understand, is climate change an objective that we have really followed across, or is that something we need to develop in the future?
Yes, that's a very good question to ask from me, because I'm just came back from COP27 representing the Sri Lankan delegation as well as the Association of Commonwealth Universities. I went there as a researcher, represented Commonwealth Universities, and also last week we in the sense the SAARC countries published the most updated publication called Project Bhajo. That is, Bhajo is a Napoleon version of climate change, and together with Kathmandu Law School, Faculty of Law, University of Colombo, and all the other 8 SAARC countries together, we publish, the university students led the UN Millennium Fellowship Program, and then we publish this updated publication on climate change in South Asia.
Right.
So your question is whether we are at the right point in terms of addressing climate change. I would say that there have been many international standards in place And we can see the main convention, United Nations Framework Convention on Climate Change, as well as Kyoto Protocol, and then later on 2015 Paris Agreement. Sri Lanka has been a party member to all of this. So Sri Lanka in the forefront, I would say, from the developing countries' perspective in the climate change debate. But my main problem is actually when we make laws in environmental protection and particularly climate change, we are very much lacking certain areas that the other country, the rest of the world, mainly the West or even India, is far ahead of us. What are those areas? Those areas are, we never see environmental problems from multidisciplinary perspective. So we do not have a particular act dedicated to climate change. So I think that is a timely need that we need to consider, because we only have policy regulations, planning documents and policy documents on climate change. Whereas in Pakistan, they have a separate ministry for climate change. So that is something that we have to take very seriously into consideration as a Sri Lankan society and also the governing mechanisms. So I would suggest that we have to have proper data, scientific testing, and also weather and climate information. That part we are terribly lack in. So we do not have any updated information. So that is a finding that we have in this book publication about the SAARC countries. Sri Lanka is far behind that. But we have many progressive policy documents and regulations. And also at the ministerial level and at the Central Environmental Authority, there are many programs that is dedicated to climate change. And also we have a separate climate change secretary within the Ministry of Environment, which is, I think, is trying to do many progressive approaches. But we have to have a giant step here, because the rest of the world is fast moving with climate change debate, and there are many funding mechanisms and also many collaborations going on. And something that I observed at COP27 in Egypt was that Sri Lanka is not even visible within the world map when it comes to climate change. But we are in a highest priority list when it comes to the vulnerability. So in 2019, according to the index, that we are in the second position of vulnerability. So
that is from the entire world, or
yes, entire world. So, and also we are an island nation. So the risk is very high. So I mean, who created the climate change and who is responsible, and whether the North-South dimension is in that political part is always been there. But how do we as a developing country using that so-called political debate to attract some benefits and also to protect our mother nature within the Sri Lankan territory? That should be our priority. So in order to do that, only legal arguments won't do. Legal arguments should be supported by scientific evidence, political phenomenon, and also economic statistics. So all of these multi-disciplinary approach is very, very important, because climate change at the end of the day is a cross-cutting matter. So that kind of a vision should be there with the policymakers when it comes to climate change. So highest priority, we must have some kind of a act passed by the parliament to define climate change within the Sri Lankan context and identify, recognize the problems in relation to that. And also we must have scientific community and also economists, sociologists, everyone should work together as a team towards the protecting Sri Lanka against the climate change.
Doctor, sorry. Professor, one thing I really liked in the way you framed the entire issue is because when we have a lot of environmentalists come to speak to us, they wouldn't think of all these dimensions. And as you very rightly, and I think that's why this discussion would be productive as we go along also, there are many elements that we need to consider, and the result of all of that should be what we give as a give for the climate change. Before we go in for a break, Professor, something I want to just clarify with you shortly. What are the key elements within the National Environmental Act, without going into reforms or without going into amendments, that are in contention as of now? As in, what do you see as the problematic areas that constantly have a sort of issue in terms of practicality, or has a certain conflict with people on the ground, where cases come up almost on a constant basis? What are, if you can take out one issue and say, okay, this is one particular problem area, what would that be?
Danidu, as I mentioned earlier, I would think that as a professor in environmental law, I would say this, National Environmental Act is sufficient.
Right.
And it has many regulations introduced later on. So the minister, in consultation with the Environmental Council and all the secretary and other parties, he can introduce regulations to prevent further damages to the environment. But the current National Environmental Act has sufficient provisions. For example, it has amendments later on. This National Environmental Act was established in 1980, number 47, and then later on we have amendments. So those amendments introduce very, very important, very significant areas of environmental protection, such as environmental protection license mechanism, environmental impact assessment process. So there are ways and means that is given by the provided within the National Environmental Act, if the wisdom is there to utilize that. So I don't have any problem. I think it is very consistent to address the current issues. Enforcement and also having a vision to look at environmental problem from a multidisciplinary perspective is where we are lacking. Yeah. So that is where we should find the solution for.
Yeah. I think that's very well put, Professor. We will take a short break, and I think a lot of questions that have risen to me would primarily be on the practicality side of everything, and we'll talk to Professor Kokila Konasinghe about all of that. You're watching Law, Land and Liberty. Stay with us.
Hello, my name is Kaushika and I'm a PhD student at RMIT University, Melbourne. My question is on remedies. What are the remedies against damage to the environment, and how is the sustainable use of the environment guaranteed?
Welcome back to Law, Land and Liberty. We are in conversation with Professor Kokila Konasinghe. Professor, within our first segment, I think what we laid out was the fundamental law. And I think you gave a very comprehensive defense of why we already have the elements. Now in this, just to unpack it step by step, we are going to talk a bit about the remedies. Before we go into the elements there, if I can get an identification of the authority that is in charge of overlooking this, because again, in every, I think, program we try to talk about the authorities that are involved in specific areas, and we often come back to the police. And police, or maybe even the Attorney General's department, but that would be a different role altogether. If it is the police, are they equipped with the knowledge or the technical wisdom, I would say, to deal with these matters? Is that why we see a lack in sort of the enforcement? Or is there another authority that needs to step up and take involvement?
Right. That's a brilliant question, I would say, because as someone who is very passionate about the Sri Lankan nature and environment, this is a very big platform for me to make the people aware of what is actually in the law. Now, Danidu, National Environmental Act is established in 1980. For the main objective of the Act was to establish a central environmental authority.
Right.
So the main body, government entity that is responsible for environmental protection is Central Environmental Authority.
The CEA.
CEA. And also we have a Ministry of Environment and Mahieash Development. That is another entity that is that comes under the environmental protection. And also we have Wildlife Department, Forestry Department. So there are many legally authorized entities to look after different components of Sri Lankan nature. And also the constitution has some very fascinated provisions under directive principles. 2714 of the directive principle of the 1978 constitution states that the state, the government, has the responsibility to protect, conserve and enrich the nature of this country. So the government is liable, is responsible to protect, conserve and promote the environmental quality of this country. And also, interestingly, under Article 28E of the 1978 Constitution, the people of this country, whoever lives in this country, has a duty towards protecting the nature and its riches. So this is an amazing provision, I would say, because the citizens, the government and all the government entities that is responsible to protect the nature. So according to 2714 article, what is the government? There are three segments of governments: executive, legislative and also the judiciary. So based on this, actually in the Vilpattu judgment, the Honorable Court of Appeal judiciary officers mentioned this provision and said that the judiciary has a responsibility towards creating laws to protect the Sri Lankan environment. So I would say not only the police has some, police also has a unit, environmental unit in this country, particularly dedicated to protect the environment. So as you can see, this is what I meant. The laws and the legal framework and the institutional framework is sufficiently in place.
Right.
The problem is effective environment, creative judgments and effective implementation of law. That is where the Sri Lankans together, government, citizens, police and also the department, Central Environment Authority, ministries have to focus on.
Professor, just to delve deeper there, I think you sort of opened the window with the conversation on the Constitution and what's enshrined within the Constitution with regards to how we identify the environment. Now, I think the best, one of the key figures was Justice C.J. Veeramantri, who had once said about how environmental rights also should come to the extent of a human right, and that is the consideration that we need to give, and that was in the ICJ. So the magnitude there is understood, but when it comes to remedies, if we can, I think that is some place I want to give you some time to really explain. How are these rights identified? Because even for me, it would be a confusing sort of situation, because I wouldn't be clear whether it would amount to a human right violation, whether it's the Supreme Court you would go for in the event of a large-scale environmental issue. That clarity, does it exist? I mean, it could be my own ignorance in that case, but does that clarity exist, and how can we make that clarity even better in this, better understood?
Yes. Now, human rights approach or fundamental right approach, whatever the provisions that we take from the larger human right scope to and incorporate it into our constitution are called fundamental rights. So not all the human rights are fundamental right. So Sri Lanka has Article 10 to 14, our fundamental rights are enshrined in the constitution. And right-based approach always construct on human beings. So there is a problem when it comes to animal protection and also the other segments of the nature like mountains, rivers, trees, ocean. Then how do we address this problem? The first approach that other countries, particularly countries like India, is in a very progressive path towards this right-based approach. What they did was they used the existing fundamental rights provisions in the Constitution to include environmental protection elements within it. How do they do this? They have Article 21, that is right to life. So everyone has a right to life. So what the creative judges and also creative, very liberal, very very thought-provoking lawyers, what they did was, together with the civil societies, they brought up this concept, right to live in a clean and healthy environment. Yeah. So just mere living won't be sufficient. So people should be guaranteed that they live in a healthy environment. Then comes the environmental protection part. So by this, using the existing provisions and then greening the existing fundamental right provision in order to incorporate environmental protection elements within that was very successful in other countries. Yeah. That is what actually Sri Lankan public interest litigation lawyers have been doing this far. What they did was, we have Article 11 that says freedom from torture, cruel, inhuman, degrading treatment or punishment. So they use that provision to emphasize that if the environment is polluted, and then that's a suffering for people. So it's a torture, it's a cruel, inhuman, degrading treatment. Yeah. So they interpret in that way. And also we have Article 12. So everybody should be ensure that they have equality guaranteed in every term in their life. So likewise Article 12 and also Article 14, we have right to choose our place of living and shelter, right to shelter and also right to lawful occupation. So those provisions, existing fundamental right provisions, were used to argue environmental law cases which have been very successful so far even in Sri Lanka. So Eppavala case and also Wilpattu case and Chunnakam power plant case are landmark cases that use these provisions within the fundamental right provision. And there is another way that we use right-based approach. That is to have a separate right on environment. Okay. Countries like South Korea, South Africa and many other countries in the world have separate right to clean an environment. Now there was a constitutional amendment committee, expert committee was appointed a couple of months ago, and then they were analyzing the new amendments to the constitution. And then actually from our organization, Center for Environmental Law and Policy, we proposed this proposal to have a separate provision in the Constitution among the fundamental right provisions, a separate provisions which says everyone has a right to clean and healthy environment. Yeah. So that is a separate provision on environmental protection. So there are two ways that we use this right-based approach. One is greening the existing provisions and incorporate environmental elements into that. Second method is that have a separate fundamental right to clean and healthy environment. So both of these ways serve the right-based approach in environmental protection.
Professor, just to get a clarification there, so the application should be made to the Supreme Court in those instances. Is that how it is going to work?
Yes. Any provision with regard to any application with regard to violation of fundamental rights should straight away go to Supreme Court. According to the existing Constitution, read in Article 17 together with 926, it is assured that the application should be straight away go to Supreme Court.
Professor, just developing on that, if you can, I think it will be very helpful for most of our viewers to get an understanding of, now you mentioned a few landmark cases as well, the Paula case, Vilpattu case. What are the key sort of like salient features that you can that we can grasp from that a normal individual could really like use in their day-to-day encounters with people polluting the environment, or so that they have an understanding of, okay, look, there is a fundamental rights violation that is happening in front of me, though I have seen it for quite some time, I maybe have not been able to identify it. What are the lessons that we can take from the common law that you sort of like explained?
Yes, I would also like to mention the criminal liability here as well for general public. Now, if there is a garbage dump near your house and then couple of people in the neighborhood are suffering from this garbage dump, then the best thing would be to make a complaint to the magistrate under the article section 98 of the Criminal Procedure Code. So the citizens can, if they are suffering from this menace by this garbage or whatever the environmental pollution, they can always go to the magistrate. So there's a ample of choices that for the general public, if there is a branch heading over that could make a danger. So even imminent danger, you can go to the magistrate and then make a complaint to the magistrate. So magistrate has a wider authority there to make decisions. So I think the best solution would be under the public nuisance section 98 of the Criminal Procedure Code, and also reading with Penal Code 262 onwards, there are provisions for public nuisance. So that is a very good practical solution, I would say. But if you go to the right-based approach, then you can go to the Supreme Court using this Article 11, freedom from torture, inhuman, degrading treatment or punishment, and also Article 12, 1, equality, and Article 12.2, non-discrimination, and also Article 14, there are many provisions. So what I would say is, if you feel that your rights have been violated and by the act of, can be a local government authority or can be a private company. In Chunnakam power plant case, it's very interesting. The groundwater was polluted not by the government entity but by a private company. So this happened in Chunnakam area in Jaffna, and then the Honorable Supreme Court held that the private company is liable, but the private company undertook that project to build a thermal power plant with the license provided by the Central Environmental Authority. So the government entity also come into action. So the government entity is liable, and also to pay compensation, the private company was also liable. So there are some other interesting concepts and principles in environmental law that were used in these three landmark cases. Those are polluter pays principle. Even in this case of the oceanic pollution, marine pollution that happened with Express Pearl, the polluter pays principle came into discussion. So polluter pays principle was very vividly applied in the Vilpattu judgment. That is how the former minister was liable to reforestation, because polluter should pay. So polluter pays principle, and also there are principles like precautionary principle and sustainable development concepts. So those principles are also have been used by these judgments. So I think the best solutions are all over the legal framework of Sri Lanka. The problem is people are not well aware of environmental law, and also there are lapses in enforcement.
Right. Professor, I think that clarifies a lot of doubts that people would have. I have a few more issues that I would like to get a small clarification before we go for a break. One thing, Professor, that you did mention as you went across these rights, there's another element that we can look at, as in from the user's perspective, as in where do we draw a line between an individual whose livelihood depends on the environment, either fishermen or someone who has to deal with forests. How does that work, Professor? Now there is I think the fine line between exploitation and now the livelihood of an individual whose family depends on this as well. How does the law come into place there? Are there remedies for those individuals also, because they are also part of our economy, and we should find sort of like a inclusive solution to all of that? How do you see that?
That's a very, very good way of looking at that, because for any environmental problems there are three segments. One is economic issues, the other one is environmental issues, and the other one is human rights issue. So social, economic, environment. Unless you maintain these three pillars balance, you never can achieve sustainable development. Yeah. So that is why we have tools like environmental impact assessment. So for any major environmental problem project, if you are going to implement environmental problems that could make adverse impact to the environment, you have prior information, and based on those prior information you can make alternatives to the project in order to make it more environmental friendly. So I think there are tools that we can use to provide solution. But to a very interesting way that you look at these problems, any environmental problems have to balance this conflict of interest of the people whose livelihood is involved in these projects, and also the development interest. So that is why we have this environmental impact assessment, to make the balance between these conflict of interest.
I think that makes sense, Professor. I need to give you some time to talk about the reforms and what we can learn from the international cases that are involved with the environmental cases. But we'll take a very short break. You're watching Law, Land and Liberty. Stay with us.
My name is Udeshika Gamangoda, and I'm the Digital Marketing Manager for a luxury hotel chain in the Maldives. My question today is about reforms. How can the laws protecting the environment be strengthened?
Welcome back to Law, Land and Liberty. We are in conversation with Professor Kokila Konasinghe. Professor, for this segment, something that we want to touch on was reforms. But prior to which, a segment that we missed out on was the rights of the environment, and to look at that in that angle. How exactly do you approach that? Because you made an explanation as to how we can intertwine the already existing rights of the human rights, basically, that everyone is aware of, to showing how the environment is related to it, and therefore the environment should be protected. But when it comes to environment rights in general, I think exclusively talking about it, how do you exactly approach that?
Okay. If we go back to very, very long time in the ancient history, we treated the sun, moon as gods, and we worship even the rivers, mountains. Now the world is moving towards that direction, Danidu. Now the world is realizing, to live in harmony with nature, we have to treat the nature as another sector of the nature, just like human beings. So we cannot live in isolation. Now so far what we have been doing is, we have utilized the environment, nature, for our benefit. For the industrial manufacturing process, we use water, air, soil, minerals. But now the world is increasingly understanding that the path that we have taken so far is not going anywhere. So we have two approaches when it comes to environmental lawmaking. One is, so far what we have been doing is, we make laws looking at the human beings. So what impact we have from the environment, and also what benefits we can take. So based on that we make laws with the environment. But now we have largely failed in that decision making approach. So what now we are going to do is that we are going to use ecocentric approach. Ecocentric approach means we are looking at the environment from a holistic perspective, and we only human beings are not in the central focus when it comes to decision making, but we look at other species, other segments, fauna, flora, everything together. In this, now there is an interesting dialogue is developing in the world at the international level called rights of nature. Now what we have been discussing in this program so far is human right to environment, fundamental right to environment. No more the world is discussing about that. Now the world is discussing about rights of nature. So nature includes human beings as well. Yeah. So we are looking at the nature as another legal entity. Okay. So as a person who is from law, you know that in order to go to court and file a case or against yourself, you need to be a legal person, either legal person or a natural person. But where do we place the environment here? Now there have been solutions coming up from different parts of the world. In Ecuador, the constitution in 2008 had this amendment to include rights of nature as a fundamental right. Okay. So within the fundamental right, they say that the nature has a right to protect, conserve and further developments. So the nature has, okay. So nature has identified as a legal person in the constitution.
That's in Ecuador.
Ecuador constitution in 2008. And furthermore, in New Zealand, we have a separate legislation called Whanganui River Settlement Act in 2017. In New Zealand, what does it say? It says that Whanganui River is a legal person. Whanganui River can come to court claiming his rights and liabilities and all the corresponding rights and duties and all the rights that a human being would come to court with. Yeah. So that's a very interesting approach that the New Zealand Parliament passed this act in 2017. Yeah. Whereas Ecuador constitution was adopted with the provision of rights of nature. And we don't have to go that far. Even in the neighborhood India, we have two cases, judgments coming from Uttarakhand High Court saying that the glaciers at the beginning of Ganga, River Ganga and River Yamuna, we should protect the glaciers, and glaciers in Ganga and Yamuna have legal rights. So the rivers can come to court claiming not to be polluted. And also in 2022 April, this year April, we have another very interesting judgment from Madras High Court. Madras High Court, referring to all of these judgments all over the world on rights of nature, stated that the nature has a right to be protected. So now, under this concept of rights of nature, it's a movement now. All over the world, rights of nature is a movement. So the environmentalists and eco-friendly human beings are now in a procession to claim in for rights of nature. So the mountains, rivers, all the sectors of the nature can go to court with their rights. But there is an interesting argument against this. What is that argument? If you go claiming your rights, you should be able to liable too. Okay. So for example, in the this Lalit Miglani case in Uttarakhand in India, on river Ganga and Yamuna, those two cases, and the defense lawyer said that if a river flooded and then killed people, can it be liable for manslaughter? So that's an interesting argument, that all the right of nature movement scholars needs to find a solution. Now in the legal scholarship, there are suggestions coming up, there are new findings to establish not a legal personhood but a legal naturehood. So it's a different concept that the court has to revisit their judgments and find a space for the nature to be considered as a person before the court.
Professor, just to, I think it was a very interesting argument as you mentioned. Just to get a clarification there, you can't in fact hold nature accountable. I don't think there is any instances that can occur. Is that what can be understood from
then
that?
I as a lawyer has a very interesting argument because now suppose there is a flood. Who is responsible for causing the flood? So if you go to the root cause, it's mostly it's Anthropocene. So it's human beings. So the problem is Anthropocene. Human created the problem. So again, it can be the finger point at us, I think.
I think as a last question, Professor, what I want to ask you is from the, I think you gave a very good analysis of what's happening around the world. What are the lessons we can learn from that, and as a country, how do we move forward from this point onwards?
Now, in the journey towards these current contemporary developments of environmental law, once we are far ahead of the world, what I am talking about is 2,500 years ago, at the International Court of Justice, Judge C.J. Veeramanthri very vividly explained this in the case Hungary versus Slovakia, where he referred to some of our ancient documents, Mahavansha, Thupavansha, and then he pointed out that the irrigation system in Sri Lanka, the engineers consider how much concern was given to environmental protection together with the development project. For example, Mahaparakrama Samudra.
This was the Gabčíkovo case.
Gabčíkovo Nagimaru's case, and it is recorded as Hungary versus Slovakia. And in that case, he very vividly explained how the Sri Lankan irrigation system and the governing mechanisms was focused on maintaining balance between environmental protection and development. Yeah. Now where we are. Now I am here proposing to consider rights of nature, to give nature a legal entity at the court. But have we sufficiently incorporated even the right-based approach when it comes to environmental protection? No, not so far. So first we need to consider incorporating right to clean and healthy environment for human beings. And then we have to consider taking proper care as a duty of care as human beings to the environment, and then we can consider rights of nature approach. I think it's a long way behind, but I think now I have a huge respect for the younger generation. I can see that even at the international level, this youth in climate action is very, very strong movement. So I think the Sri Lankan youth also is showing positive signs. So I have a hope for the future, let alone the present, but the past we can be proud of, but present I think we have serious concerns. But future, I think Sri Lanka has a hope with the younger generation. I think I have a hope with the environmental protection, because the younger generation is looking at the environment, and I think it won't be a surprise concept when it comes to rights of nature application in Sri Lanka in the future.
Right. Professor Kokila Konasinghe, thank you so much. As usual, it's a very interesting discussion to have with you, and I think you framed a lot of issues very well and gave a lot of, I think, sometimes even homework for us to really go back and read on of how we can understand this topic further. Professor Kokila Konasinghe, Professor in Environmental Law at the Department of Public and International Law of the University of Colombo, and the Founding Director for the Center for the Environmental Law and Policy. Thank you so much for joining me.
Thank you.
All right. The variety and the scope of the environment is vast, an aspect that the law should keep up with, as we discussed within today's segment. Former Vice President of the International Court of Justice, C.J. Veeramanthri, a stalwart for the protection of the environment, once said, The law can be greatly advanced, especially to suit the needs of the 21st century, when we are moving in the direction of being global citizens with common problems such as the environment, common aspirations for a peaceful world, and a set of universally shared values. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/AdaDerana English. I'm Daniel Tanwasa. Have a great night.